And we're live. Yay! Hello, everybody. Welcome to this week's Legal Surgery. I'm here with Alex Woods from Court Wingman, and we're here to answer your questions. Well, I'm here to just ask them for you. Alex, do you want to say a couple of words before we start?
Yeah, I've got new glasses, but on the downside, I'm now having to wear silly headphones that make me look like Princess Leia from Star Wars. There are actually some pictures circulating around where you've got kind of like a pussycat with a silly earmuffs on. I mean, you can. It's very easy, basically, to look like Princess Leia from Star Wars these days with all the technology that's around and the headgear that there is. So I don't. Basically, what I'm trying to say is I don't feel particularly authoritative and, hard-boiled lawyer-like with these headphones on. But this channel is all about getting the content out there, not worrying too much about the elegance of our surroundings, providing the sound quality is good, and you're getting the material. But over time, we will be, I'm sure, flowering and blossoming in completely fresh ways. And at last, we do have the opportunity to do that, to be more expansive in what we're doing, because we're closing down Redwood Legal, the law firm. And we're going to position ourselves as advice and assistance to the great British unwashed, or anybody who's got a legal dispute in the UK, through our Court Wingman service. We already have existing relationships with law firms. I quite like the idea of being able to then, where someone does actually need full representation, we can refer to specialist solicitors who I'll know, who you won't. One of the big problems I'm experiencing is people just don't know which lawyer to choose. That's a big, barrier of entry, is just not knowing how to find a decent lawyer, and one specializing in their area. So we'll operate as a court wingman service to help you run your own case, primarily, you being the litigating person, which I think is quite exciting, because you really so much is done on the papers that you really can do a lot yourself with a lawyer in the background, or in the control tower. You can draft up your particulars of claim. That's the most important document there is. Hardly matters what you're saying in court, but at the trial, it's too late if you haven't got your particulars of claim right and haven't produced the evidence. So I think we can offer quite a lot of valuable, cost-effective service through the Court Wingman service, and we can now kind of dedicate ourselves to doing that. King, have you got anything to say about your proposals for the website, which will be the doorway into the gateway into the service that we offer?
Oh, there will be some changes on there. I think the main one is the fact that you'll be able to pay directly on the website and book a appointment for the legal surgeries. And just on the point of moving away from being a law firm to being more like a company, I think it's really important to stress that the service practically kind of remains the same, because this is what we have been doing for the past years, effectively, on top of paying all the legal fees that are behind running a law firm that aren't necessarily needed. So I think that's the main one. But Alex, you're still going to be a solicitor, aren't you?
Yeah, that's exactly right. The problem I've foreseen is it's very difficult to run a business. You may think that all lawyers are rich. Well, that's just simply not true. We work long hours for not much money, but with a huge headache of a heavily regulated business. So much compliance, so much accounting, so much risk, complaints, insurance. It's expensive and time consuming. And it's just not, I don't think it's the right business model to, I've been forced into this position really, because we just haven't been, it's difficult to run a business when we're offering this type of a service, if it's a law firm. So I think I'm hoping this in a way, forced opportunity, as it were, will be a good platform. Yes, I will be solicitor still, and Daria and me will be are already now signed up with another law firm, but we won't be owning it or running it. We will, so that if you do need us to represent you, we can still do that through the umbrella of another law firm, South Bank Legal, with its headquarters in London. So we can still litigate on your behalf. So that's that. But if you are a litigant in person, the courtwingman.com website is the place to go, and you won't be able to email us at Redwood Legal. You'll have to email us at hello@courtwingman.com.
Yeah, I think that's we covered everything that's necessary. More on this next week anyway, and there'll be information on the websites and throughout the web as you search for us and our services. Anyway, should we get started? Are there any questions, guys watching? If you do have any questions, do put them in the live chat right now, or email hello@courtwingman.com with the subject title the YouTube live, and then include your question, so that we could discuss both the problem and give you an answer here if you're stressed about writing on the live chat. But if there won't be any questions in the next few minutes, I think we can talk about the most recent case, Alex, that you had that was very successful.
Well, yeah, a chap got in touch this week for some more legal advice on another case, but he'd taken our advice. It's often the way it happens. Like a year later, you get someone giving you good feedback. About a year ago, he was suing a bank, and I think banks are such a pain in the neck, because they put you through their complaints procedure. They treat everything as a complaint, which means you don't get any contact with the actual human being. You just get processed. You get bounced around a call center. If you're lucky, you get bounced up to a complex division of the legal center. Maybe you'll get all the way to a law firm or a legal department at the bank. It is such a, I mean, I think banks are dinosaurs, and I think it's time to move away from the main high street banks. I noticed there are new, what's called challenger banks. I think one's called Starling, and I'm thinking about using that type of bank for my business. It's just, it's got too ridiculous. You know, the bank wrongly deducted £1,000, didn't do a basic transfer to a credit card of £1,000 on my normal personal bank account. It left my current account and didn't go into my credit card. And I ring them up and they're like, oh, sorry, yeah, it's clearly an error. And yet, you know, okay, so you're going to fix it. Yeah. All right. So nothing happens for two weeks. Bring them up. Oh, here's a number for you to call. We can't handle your call on this. We can't handle your query on a Saturday. Call this number next week. I'm like, why am I having to call a number? You should, I'm telling you the problem. Can't you sort it out? And you build up this head of steam with a bang. They still haven't changed it. And £1,000, I'm now getting warning, your credit card is in danger of being overdrawn. Yes, because you didn't credit £1,000 to it. Oh, didn't the first operator tell you it can take 5 weeks to sort out this problem? It's not really a problem. I clicked on my credit card, top up by 1,000. I saw that the money's left the current account, it hasn't gone to the credit account. Yes, we can see that, sir, but there is a delay time of 5 weeks.
5 weeks to transfer money on the day. That is ridiculous. Yeah. Well, but to stop you from ranting, I suppose, we've got a question here. Top 3 things for representing.
Just finally, but the point is, this chap took some advice. I said, he was bringing a claim, but the problem is if you bring a claim against a bank, he was writing a letter of action, a letter before action, letter of claim. But the problem is it still gets stuck in the bank's main complaint center. So what I said to him is, draft up your particulars of claim in the M1 claim form. Don't issue it, but send it to the bank and tell them you're going to issue unless you get a response. That draft then alerts the call centre, who go, oh, it's a legal case. Then it gets referred to a lawyer in the bank. Then it gets some individual attention. So that's a clever trick, because a letter of claim will get clogged up with the complaints department. Drafting up your particulars of claim, the M1 claim form, and sending it to your opponent and saying, this is what I'm going to do unless I get a response, will concentrate their minds and get it referred to the legal department of the bank. And that's what you need to do, because until you do get it categorized as a legal dispute, you'll just go around the houses with the complaints department offering you £50 and, saying sorry a lot.
Yeah, that's hardly a resolution.
So that's that. Yeah.
Okay, on to the next thing. What are the top 3 things for representing your own case in the small claims court?
That's a nice, good general question, isn't it? Did you write that question?
No, I didn't. No.
The top, perhaps Daria's listening. The top 3 kind of must-dos if you're bringing your own claim in the small claims court. I would say, don't issue without having laid out the claim properly in a letter of claim first. Don't just say, right, I'm issuing proceedings, see you in court. You need to have drafted up your claim in a letter of claim beforehand, but that can then be used as the basis for drafting up the claim itself. You can almost copy and paste it. So that's very important. The other top tip is more general, which is people always think that they're 100% in the right. Have you noticed that about life? We always think that, no, well, I'm completely right. And the ability to be able to step outside your own case and to look at it with a cool, hard, professional eye, even to actually imagine what the other party are going to say, what their case is. That process of being able to be cool-headed and professional, that's really important. And if you don't do that, you'll wrongly inflate your claim form, your claim value, for example. You'll get in trouble with costs orders against you. You won't make intelligent offers at the right point. All these are very important things because civil litigation is about costs. Certainly for claims on the fast track over 10,000. So mistakes of that nature are liable to hit you hard down the track in terms of cost order against you. So that's the second thing, being able to be detached about your case and see it as an entrepreneurial endeavor and make sure that it's commercially viable. It's not about justice or righting wrongs. Yeah. The third thing is paperwork. I think case management, we've done a video on that. And I think I like this chap who did the draft particulars of claim to the bank. He's got another case. And I kind of know he's going to win because I can see it's a small claim. I can see he's just cool-headed, organized, got his paperwork in order. He's done a chronology of the case. You know, he was every bit as smart as I was in a way, as we dealt with these issues in this case. He has. He'd read the books. Is a real vindication of that you can do it on your own if you're a litigant in person. And anyway, I just think he'll win because his paperwork is organised. He's done a chronology. So those, I would say, the 3 top tips. Make sure you've exhausted pre-action steps before you issue proceedings. what was my second point? Be entrepreneurial and professional, cool-headed about the value and merits of your own case, and preparation, paperwork. Get your paperwork organised, because civil litigation is all about paperwork.
On the first,
in fact, just on a news item front, we got a court order this week actually saying, would you like the judge to determine your case on the papers? I've never seen a court order like it. And I guess it's because of the coronavirus. The courts are really, county court systems really creaking. And they're just flat out. And they're now trying to get people to just have adjudication of their case without ever getting in a courtroom. It's obviously not mandatory. It's just something that the court has offered in this particular case.
well, on the first point, first tip, the person who asked the first question then asked a follow-up question, which is how to present to the judge that the other party won't entertain mediation. I've offered mediation to them 10 times.
Well, providing you've offered it in an email or a letter formally, and if you've got, they've either ignored him or her or they've refused. In civil litigation, you're laying mines that you're going to blow up in the future. So you take that written refusal and your written requests, and you adduce it as evidence at the appropriate time. It might be with your witness statements. When you exchange witness statements, you might mention it in a witness statement. If there's any type of case management hearing, which there often is, or preliminary hearing, you print out that correspondence where it's likely that the court will raise the issue of, have you guys tried to resolve this without court proceedings? Then you seize that opportunity of any court hearing to get that evidence in front of the judge. So those are things that you can already do. There's sort of points in the litigation timetable that you can avail yourselves of, because the judge is always looking at any particular hearing, not just at what the hearing is for, but generally what sort of management this case needs. If he decides it needs mediation, he'll want to see the correspondence in which you've asked for mediation and they've refused it. Ultimately, that correspondence may be used after you've won or even lost, and the judge is saying, right, now what about costs? Then you say, well, I think you should award me my full costs because they rejected mediation, here's the correspondence. Or you should say they shouldn't get their costs even though they won, because they refused mediation, here's the correspondence. And you do that after the actual trial. Or if it's a separate costs hearing, which there often is. You could also write a letter into the court at a particular stage, bringing the fact that they failed to. I occasionally will write a letter to the court, copy the other, make sure to copy the other side, laying out how it is they've failed to try and settle the matter with alternative dispute resolution, of which mediation is just one type of alternative dispute resolution. Again, that letter can then be used on the issue of costs when it comes to the end of the case.
Thank you for that. If any of you watching are wondering what the heck do all these legal terms mean that Alex is just throwing around, you will find a glossary of terms in this book that came out not so long ago. You can download the free chapter on our website and on book.courtwingman.com, and that will include a glossary of terms. So whenever you're watching something on our channel and you're like, what the heck is that? This book will have it. And then you could just refer to terms and understand everything that's going on. Anyhow, on to the next question. How much is an application to county court for a summary judgment? Is it considered a Part 7?
I don't know.
Where do you find out such information?
I don't know that I've ever applied for summary judgment. It's very rarely done. Think carefully, whoever's asking the question, what it is that you're asking for, and is it the right avenue? I cover it in the book, summary judgment, but I don't know whether the application attracts a court fee, because it might not. It's in the same category of group of kind of weapons in the armory as a strikeout application, for which you do have to pay a court fee of £255. Is it 255? Is it 155? What you need to do is go on to, if you just Google EX50, okay, court fees, that will bring you up a document, and that will make sure you've not got the family court one. Make sure you're looking at the civil court section. And it's an interesting document. It's really helpful with the court fees. Make sure it's the most recent version, because there are a lot of older versions floating around on the internet. And you'll find civil court fees, section 2. You'll find the banding for fees generally, any fees. In relation to summary judgment, it might be that there's a section which says application on notice where no other fee is specified. That's like, if you can't find anywhere else summary judgment, what's the fee, or strikeout application, what's the fee, then it falls into where no other fee is specified fee. And it's 255. Consent orders are £100. But whether there's a fee payable for summary judgment, it's a bit like another category of a type of getting kind of early resolution is judgment in default, which is far more common, where someone hasn't paid. It's clearly just a debt recovery matter and there's no real defence, or they haven't responded to your claim. Then you just apply for judgment in default. But I don't think that you pay any fees for those things. But I'm afraid I so rarely do summary judgment, because they're very rarely the right thing to do. Because summary judgment is like, oh, it's clearly, obviously a pathetic defence or a pathetic claim, so just give us summary judgment. But the problem is the judge can't really assess that at such an early stage of proceedings until he's seen witness statements and disclosure and other evidence. So that's why it's not very often used. So I would just check to make sure that summary judgment is appropriate.
That's a good response. On to a slightly different topic of wills. If a person has a joint will, dies, then spouse dies years later, like 7 years, is that will still legal?
Yeah, that's one of those possible to answer questions, isn't it?
It depends.
Yeah, it's just not that it depends question. Just state the question again.
Oh, we'll have to wait for Galaxy 20, the account. Could you give us some more information on that one? Well, what does it depend on, just generally?
Can you just say the question again so I understand it properly?
So there's a joint will, one person dies, then the spouse also dies years later. Is the will still legal?
Still valid?
Yeah.
I guess my first question would be, well, the first response is, don't know without knowing the facts of the case. Could be, it depends. But my second question, more useful question is, why wouldn't it? You've got a will. It's the most recent will, presumably, in this hypothetical example, for both. One dies after the other. Why wouldn't it come into effect if it's not been changed prior to the death of either of the two parties?
I suppose. Yeah.
Can't see a good reason.
No.
If you go back, if you go back to basic principles, it's very difficult to answer technical specific questions. It's not that technical, I guess, but to answer a specific question. But probably best to go back to the underlying question. If you don't have a will and you die intestate, then there are certain rules that can be easily found, statutory rules, which say where the money goes. Okay. If there is a will, now, if in that example, there's no other all you've got is a will, and a court is deciding where does the money go, it's going to say, well, what was the intention, of the deceased? Where do we look for the evidence of the intention of the deceased? Well, we look to a will. The will, that's the first port of call, isn't it? So it is, a will, just because it hasn't been properly executed, doesn't entirely negate that will, because the court's still got to make a decision, about what happens to the estate, and it might decide to rely on a will even though it's not being fully executed. It's not quite the point that's been made here, but this is the general point that the court's got to deal with an estate, and it will, find the evidence it needs that goes to the issue of what the deceased intended. If the will isn't properly formed, or if there is some other issue to do with one party having died 7 years later, because I bet in this example there probably is an issue that means the will might not be valid that we don't know about. Someone you open yourself to challenge. But you could still, defend off that challenge by saying, well, maybe the will isn't fully executed, but our case is that the court should go with it nevertheless. A court can order that. It's not prevented from following a will just because it's not properly executed. It just opens that will to attack from, like a Talata claim or an Inheritance Act claim, sorry.
Mm-hmm.
So I think that the start, why wouldn't it be valid is the question. And I bet if the viewer goes away and ponders that question, that might be of some use. Why wouldn't it be valid?
That's a fair response. Next question. You need to bear with me here because I don't quite understand the question, but you might do. Anyhow, it relates to adult healthcare services. So it might be quite specific and not what
doesn't sound like something I'll be able to help.
I know. But anyways, you might have general pointers. And the question is, how do I protect my right to rebuttal on a claim to court of protection assumption?
Don't know. Court of protection, don't know. Daria might know, but she's So I would email daria@courtwingman.com.
So yeah, hello@courtwingman.com.
Well,
Your best
sorry, hello, yeah.
And ask for Daria. Okay, well, next question. This, I suppose, was an easier one. What kind of instances of contact with witnesses or defendants jeopardize your case? Jeopardize your case. Sorry. Shall I repeat the question?
No, I got it. Just
Thinking of the answer.
it's a civil case, obviously. Generally, at a trial, certainly in a criminal trial, you're not allowed to talk to witnesses. Witnesses shouldn't talk to anybody until they've actually got into the witness box and given their evidence. So that would jeopardize it if you've spoken to a witness. In civil litigation, I mean, witness in civil litigation, it's, as I say, it's all done on the papers. So you go to a witness and you get them to give a statement. Basically, I'm having difficulty thinking of a situation or a problem when there's ever been an issue of this sort. It feels like an academic, it feels like the sort of question that might be asked at a law school, and is completely irrelevant in the practical litigation arena. I think we would need to know some specifics, really. You say contact a defendant. Are you talking civil litigation? And are you talking claimant contacting defendant? Nothing wrong with that. Nothing wrong with contacting a defendant. I mean, you shouldn't contact a defendant personally if they're legally represented. You have to go through the lawyers. If you went and if you went and approached a claimant's witness, if say you're the defendant and you approached a claimant's witness, on the practical level, I can't see that jeopardizing anything, really. Either that witness is deciding to help you or deciding to help the defendant. Yeah, I think you'd need a little bit more detail of what particular issue is.
Oh, thank you.
Because I don't see that it's of much relevance. It feels like a bit academic in civil litigation.
Okay, should we move on to the next question then?
I think so, yeah.
Okay. This question is phrased slightly wrong in that it's a bit confusing, but I think you'll get it anyway. Can I use a tarnish of evidence, which also was a contempt of court, to ask for a default judgment as the evidence is now defective?
I think pass. There's nothing coming up. It's a very complicated question.
Oh, have you got any
based entirely on the facts of the case about which I know nothing? You can't. I can't answer it. Let's move on to the next one. Sorry. What you guys need to do is, this is. I feel as if these people asking these questions are running their own bits of civil litigation in the county court, they're probably kind of in a world of their own where these questions just simply aren't relevant. I see it so often with litigants in person. I mean, civil litigation of a low value is all these issues. The only thing the court is interested in is what are the issues? Did was it your fault that the accident happened? Yeah. Yeah. Was it, how much injury was done? What does the expert, what does the doctor say as being the level of injury? You know, is there an issue of causation because you actually were driving, you were drunk and therefore you contributed to the accident, or something else happened that means that the defendant in the court, you know, these are the sorts of basic issues. Is the building works negligent? Do we need an expert to give evidence that the quality of the work doesn't reach a threshold? You know, what do I put in my witness statement? What do I put in particulars of claim? These questions feel very esoteric, as if people are either academics or students just asking interesting academic questions, which are interesting ones, but unfortunately we can't help with this channel. This is about practical law. You know, or they are down a crazy academic hypothetical hole in their case, and they really shouldn't be. You know, what I want to know about these, you know, the will case, for example, is where are you? Have you brought a claim? Do you want to know how to lodge and file a caveat to stop someone getting a grant of probate? How do I do that? You know, the talk about witnesses and defendants should you approach them. I never come across an issue like that in my time as a civil litigator. You know, and this question here is it just feels far too complicated to me. It indicates to me that someone's got overcomplicated with their own case and are probably not seeing the main issues. And what happens is these litigants in person get to trial, the judge gets annoyed with them, sides against them. They think they've been hard done by because they've not been properly understood, but they've just simply not understood that the judge is only interested in like key issues, not interfering with witnesses or whether someone's got a past history of you know, got a criminal conviction in their past, or all this. People focus on for some reason people focus on everything that's circumstantial, and we find it really difficult in civil litigation to focus on the key critical issues at hand, and both the procedural ones and, you know, the substantive ones.
Can I cheekily say all of this information is in this book?
Yeah, it's.
All you have to do is follow it page by page and just do what it
Well,
says. You'll be good.
We are outrageous pluggers, aren't we? But I mean, this chap who beat the bank, he got a good result. He got a really good result. In fact, he got more costs than he was asking for. I didn't ask him for the details. It seemed quite bizarre to get more costs that you're asking for. But the bank were very quick to I think settle after he'd sent them particulars of claim. And yeah, you just need to. He'd read a couple of. He'd bought 2 single version books on Amazon that were relevant, targeted to the particular issues that he had pre-action, I think.
And he did it. Good on him. I mean, I'm only I'm only advertising this because it's good knowledge. Like, I wouldn't, if it was trash, I'd just be like, okay, let's not ever mention it again.
I'm really sorry that we can't sort of help people with these questions. I feel, you know, we can't really help them with their questions, but I think we've got to start to sort the wheat from the chaff in terms of, you know, we are here to help you on a practical level with county court claims, small fast track and multi-track county court claims.
Well, next question then. Can I bring a case to court as an individual, a company shareholder in a case not yet in court? So under their name, not the company name.
What name to bring a case in and who to sue is really a really important issue in civil litigation. If you get it wrong, it can be a bit expensive to fix. You've got to see who say it's a contract claim, you've got to see who was contracting with who, what was the understanding. Let's say you're in a builder's yard and you meet a builder and you say, look, mate, I need a kitchen extension. Can you help me? I hear you're a great builder. And the guy says, yeah, my company's XYZ. We've done a lot of jobs like that. And our company name is buildersrus.com, and you can look us up on the website and so on. And the guy says, that's great. Sounds like how about 10,000? Would that? Yeah, well, we could for 10,000 we do a kitchen extension. There's been no paperwork, yeah. But then let's say that the builder tries to avoid VAT or something and does it in his name. And so when you get the paperwork through, you're a bit confused, and he's writing from personal account or whatever. The test is, you thought you were contracting with a building company, so that building company should be the first defendant. It's who you thought you were contracting with, and you would, as a precaution, and also because a limited company, particularly builders, can go into liquidation, and then you can't get your money. You probably would add him personally as a second defendant on the form. The reverse would apply. So the builder might think, well, he's obviously thinks he's dealing with a consumer who's personally liable for any debts. Yeah. And so the builder has to sue the consumer. But let's say the consumer thereafter decides to put it through the work through a company, even though it's his house. Perhaps he works from home and is self-employed or whatever, or he's got a limited company. But the builder always thought that he was contracting with an individual. Then again, it's with whom you think you're contracting. What was the understanding at the time that the contract was entered into?
Okay, well, what if you're bringing a claim into court? Would you use your company's name, or would you use your personal name to bring it to court? And what are the implications of?
Well, sorry. Yeah, no, I think this is what I'm trying to do, and I think I'm going to try and do this more and more with these questions, is to go to what's really relevant and helpful to people most of all, and the underlying question here. Because it's not like you choose which one. It depends with whom the contract was. If it's a contract claim, it depends who the contract was. So you're going to kind of, do I do it through my business? Do I do it through me? You see who it was contracting with who, and then you're stuck with that situation. Does that make sense?
Yeah, makes sense to me. I hope it makes sense to the person who asked the questions. Do say in the comments, or ask a follow-up question.
Yeah, you haven't got a free option to do what you like. It all depends who your opponent thinks that they were doing business with.
Okay. Well, the next question, let me dig it up. If the court admin failed to give a default judgment, can I ask the High Court judge to give the order of a default judgment?
Say it again.
So if the court clerk failed to give a default judgment, can I ask the
go on.
High Court judge to give the order for the default judgment?
Again, way too.
No. Okay.
Sorry.
So,
it's a really confusing question. Again, it's like we're now in the High Court. We started off with the court clerk in a court with the county court, and we're now going to a High Court. I'm afraid it's the limitations of this surgery it's just complex question depending upon the facts. What's interesting is that you need a legal surgery for an hour with someone like Court Wingman, because you're probably not even asking the right question. I find that a lot of people, sometimes people kind of want to try and prescribe us, sort of handcuff us, golden handcuffs. We just want to answer this question. They're trying to save money, etc., etc. Obviously, fair enough. And they just want to answer that question, as if that's going to solve their legal problem. But there's invariably, they're focused on the wrong question. They've got a dispute, and they just, for some reason, they're focused on this one question, and so people get a bit annoyed. They think, well, can't you just answer the question? Well, no, if I don't know the details of the case. And actually, if I did know the details of the case, I'd probably tell you that you're asking the wrong question. You're off on one.
Probably. Well, I couldn't even take the question apart into sections if I wanted to, because it's just so complex. It's like multiple questions in one.
I think there's some people out there really enjoying themselves, giving me really, let's think of the most difficult, tricky, complicated question you can ask. I mean, I don't think I'd mind. I think people should feel free to write a bit longer. What we really want to know is not your take on what the legal issues around your case are, but what your case is. Like, I've got a dispute with a builder. He wants an expert. I don't think one's needed because it's obvious that the wall fell down. You don't need an expert to tell you, to spend money on an expert, blah, blah, blah. It's a small case. That's a lovely little case. What do I do? And I might say, well, when you fill in the directions questionnaire, you mention with the directions questionnaire that you don't think as an expert is required for X, Y, Z reasons, and the other side have to ask permission to adduce expert evidence. So if you give us the facts of your case, even if you boil them down, then don't try and be too legal with this channel. We will try and get beyond the legal and just try and look at the heart of the dispute and what the problem and the issues are. Otherwise, it feels a bit like a law lecture, question and answer with a law faculty at university.
Okay, well, next one. What to say to a judge in a SCC who asked us why we didn't have a lawyer with us, where the person asking the question thought the point of SCC court is to not have a lawyer. What would you say to the judge?
Well, a judge may be quite. Yeah, I mean, I'm going to answer the general question, which is the issue of litigants in person. The simple fact is that you are allowed to represent yourself in court. So you can tell a judge to go whistle. And I remember being a geeky young lawyer, watching the famous McLibel trial in the Royal Courts of Justice that went on for months, if not years, in which some people had put some banners outside of McDonald's saying the meat was, not ethically sourced and so on and so forth. And McDonald's sued them for libel. And they decided to represent themselves. And I actually walked into the court and spent some time there. And what happened was the McDonald's lawyer knew them better than any, kind of was quite intimately acquainted with their case because he was helping them. Because there was kind of an obligation or a duty to make sure that justice was served and the case, they were given a fair hearing. I guess McDonald's were paying for their barrister to help their opponent in a way, because he had to help them with procedural points and various issues, and the judge had to help them as well. So that is now nevertheless, I sympathise with judges because they have, they often deal with such dog's dinners of cases that, and also where cases are really quite complex, you know, like contested will cases, a very specific procedure. And if you do it yourself, you kind of got to give up your job and your life, you know, for a period of a couple of years. And even then, so if a judge is saying that, you should probably listen to what he's saying, and maybe you do need to think about whether it is the best decision to try and run this case on your own. But if it's a small claim, or a moderately small claim, or a fast track claim, a normal civil litigation claim, you should be prepared to, and you are more than able to run it yourself. It's usually where there's clearly quite a lot of complexity and a lot of money at stake. And perhaps you're in danger of losing without legal representation, where a judge would offer and would venture an opinion like that and actually tell you to go and get a lawyer. Might be worth listening to.
The next question is, we have a date for hearing in my son's small claim case. The defence have served their defence prepared by an in-house solicitor by email without complying with the rules. Should I do nothing?
What has the opponent's solicitor done?
Not complied with the rules. I don't know how. There are no details.
So try and get some more information from that questioner.
Okay. Well, Nigel, could you give us some more details if you're still here?
Give us some background. Let's get into some nitty gritty.
Well, whilst we're waiting for Nigel, next question. Section 8, ground 8.10.11. Ground 8 has fallen through. Can I increase rent as it's been 2 years while awaiting court hearing? Is that your area of expertise?
Well, we're looking
tenant dispute, I imagine.
We're looking at a landlord and tenant dispute.
Yeah. And most of it was based on Section 8. And the ground 8 has fallen through.
The what has fallen through?
Ground 8.
Ground 8.
Yeah. Has fallen through.
Yeah.
Can the landlord increase rent whilst he's waiting for?
Ground 8 of what exactly?
Doesn't say. Section 8, ground 8.10.11.
Of what act does he say?
He doesn't say.
Well, I'll just go and ask Sarah quickly if she's free. Through the office. She's out.
Joanna, you can ask your question. I've just seen your latest comment.
She's out to lunch, I'm afraid.
Oh, well, I'm afraid we're going to either have to wait
somewhere else. But no, I don't know. I don't have... I don't know what act is referring to, and I'm not familiar enough with this area of law to know what ground 8 is.
Oh, on the will,
We do landlord and tenant, and Daria, but Daria does a lot of that.
Yeah. Well, on the will question from the very beginning, Joanna has just said there are 2 wills. She's the beneficiary and executor of the first will, and she believes that the last will is fraud.
Yeah, you see, this is my point, because that answers the question, doesn't it? Why wouldn't it be valid? Well, if it's fraudulent, yeah, you've got all sorts of, I mean, she's probably using the word fraud in quite a loose sense. With a will, you have undue influence. You have to go, this is a good example of why it is a judge might tell you to go and find a lawyer. Yeah, because how are you going to know what gateway to go through in order to get, because you can't just go to a judge and say this will is fraudulent. You've got to produce a document, your claim, which finds a cause of action or a head of claim without which the judge isn't going to open the door. Imagine a judge at one side of the door and you're the other side, and you're not. Your Honour, can I come in? As if I've got a fraudulent will. He says, what? He says, what's the cause of action? Well, the person was pressured into signing. Okay, well, in that case, you've got to plead cause of, I don't know why the judge is on a phone on the other side of the door, but you've got to plead undue influence. If you don't plead undue influence and make out the criteria for successful undue influence head of claim, you're sunk before you've even begun. It might be that lack of knowledge and approval. Well, it may be a mental capacity issue. It may be fraud, but very rarely do you see successful will cases where it's won on the basis that the signature was forged.
Joanna said more, actually. So she said there are 2 wills. I entered a caveat against last will at the probate registry and received a warning to my caveat and entered an appearance.
Yeah, very good. Yeah.
Well, that's all she said. So
no, that's helpful background.
Yeah.
Because there she's laid out the process that people should probably be aware of, which is that someone dies. You want to prevent the executors from getting a grant of probate. In other words, getting permission from the state that you can start distributing them, the money, realise the estate and distribute the money to everybody. Because you don't like that will, because you say it's for whatever reason fraudulent. It'd be nice to know what she says is fraudulent about this will. So if you're suspicious, you enter a caveat which prevents a grant of probate happening.
Okay, well, I suppose the best thing to do would be to email us, right?
Yeah, I feel as if, in a way, I feel as if we scratched the surface in these legal surgeries, when actually it would be better to spend a whole hour dealing with a typical contested wills case with someone who wanted advice on their case, and then because it's difficult to answer, isn't it? I guess she's got a steer though, that okay, it's fraudulent, but you've got to find the right cause of action. It probably isn't. You can't just say fraud. You've probably got to go through one of these gateways, and that hopefully, well, it sounds as if she's already done the right thing. She's put in a caveat, which means she's stopped probate being granted. The executors have said, right, well, we're putting in a warning, which basically means, no, we disagree with your caveat. We want a hearing in front of a judge in order to decide why we can't distribute the proceeds of the estate. Then she's got to spend money on lawyers or legal advice, she can do it herself, on what to do at that hearing and how to convince the court that there's a real issue here and that there needs to be a proper trial. Yeah.
Okay. Oh, well, that's good enough. Last one. This is again a follow-up from a previous question that wasn't as clear. So about the service question that we had, the defense have not asked whether they can serve by email as required by Rule 4 and have not complied with Rule 4.2 either. So technically, no service, Nigel thinks. Should we keep quiet?
I mean, in the case of lawyers, you do have to check that your lawyer, your opponent, will accept service by email.
Mm-hmm.
But I tell you what, even I served by email. I didn't check with the lawyers. We're in the middle of a coronavirus crisis, and we were. And it's like, really? You're going to ignore a very important document because it's not sent in Royal Mail when everyone's working online? Really? Okay, fine. Don't pretend you've never seen the letter. I'd quite like to see what a judge would say about that. You're going to tell the judge, well, Your Honour, it wasn't sent by post, and this firm only accepts service by post. If they get a geeky judge, maybe he'll go with them, but really? So I think common sense should be applied in the situations. If you've received something from someone by email, I'm not quite sure what this is. Is it the claim itself, or is it a letter?
It's the defense. Hold on, let me go back. Yeah, it was. They served their defense via email. So the other side is the defendant.
Yeah, sure. Yeah, especially if they're a litigant in person, I assume it's good service. Absolutely. So I would definitely not ignore that email. I mean, are you really going to take a technical point and when it comes to getting in front of a judge, you're going to say, well, I did get it and I have read it, but it doesn't comply with the rules of service, so I didn't read it. So I don't think it should, it's also a bit odd that who served it? The defendant served it on the claimant. Usually the court serves the defense on the claimant, because the defendant files his defense at court. It may be, you see, the defendant has just had the courtesy to send the claimant the defense by email, and that later on, because the courts are slow, the claimant will also get the defense through the post, with a proper stamp on it. So difficult, as a usual caveat, it's difficult to give specific advice. But my general rule is, if you can read it and it's in your inbox, just get on with it. Just get on with it. And anyway, you'll take forever. What if you don't accept it, you're just going to create delays. You're going to never get it in front of a judge during the coronavirus time. It's going to stretch on and on and on. I had an example like this today. The claimant had sent an M1 claim form, and he just filled in the description box, and he'd said in the description box, further particulars will follow. Proper particulars of claim will follow. The defendant then gets this, our client. He doesn't get further particulars of claim. The chap didn't bother to do them. but he still feels he has to do a defence. Good on him. So he did a defence because he knew what the dispute was because of the pre-issue correspondence. So he put in a strong defence. Then it got to the directions questionnaire stage, which is the stage after statements of case phase. And he discovered that his opponent had put into the directions questionnaire a long document, a kind of a document or a letter, which laid out his case in a lot more detail. Rather than I said to the client, is there anything new in this kind of mock particulars of claim document that's come through late after your defence? Is there anything that you take exception with? Because if you do, you should go to the court and say, I should have a right to do my defence only after I've seen the particulars. And I had only a small little N1 claim form box saying that further particulars would be followed. They didn't. I had to do a defence, and now I've got these further particulars, detailed particulars. The chap said, I think my defence document's still strong and it still stands. And so there's no point in, you could take a point, like winning litigation brownie points and say, well, I'm going to make life difficult for my opponent. I'm going to require him to file, proper particulars of claim, and I'm going to go to the court and ask for time to do a completely fresh defence. So you can see how a lot of times, particularly in a busy, underfunded kind of court system, you want to look beyond all the technical, geeky stuff and just crack on and get the claim on the tracks and cooperate. Yeah, rather than win geeky points. If you're not a lawyer, you shouldn't be trying to do clever geeky things and win procedural points unless you're. The test is, have you been genuinely prejudiced? If there's some reason the email service genuinely prejudices you, my advice 8 or 9 times out of 10 would be let it go, assume it's effective service, and just crack on.
Let it go. Okay. Going back to another question that we were, and I think this might be the final question, although Joanna also asked a follow-up question about the will. But anyhow, first one is, can you request a default judgment if the other party failed to acknowledge service in the time required?
Can you request a default judgment? Yeah, if they haven't acknowledged service, they have to have done their defence within 14 days. If they have, they've got 28 days to do their defence. But so if you haven't got a defence and you haven't got an acknowledgement of service 14 days after you've issued your claim, then apply for default judgment. Typically, I would leave it until the 28-day mark. Don't apply for default judgment on day 15 or day 29 if they have filed acknowledgement of service. So leave a good amount of blue water before you bring a default judgment application. Does that answer the question? I think it does.
I think it does. Well, just going back to Joanna, and then we're done because we're already over 10 minutes. So there are the 2 wills, and Joanna is asking, could you let me know if I can enter a citation to propound the last will? In other words, now that my title is permanent, can I enter under Rule 48 of non-contentious probate?
I can't start talking about Rule 48 under non-contentious probate, I'm afraid. That is now becoming a quite a geeky question that really does need an individual response, doesn't it? You can see it's really very specific.
It is very specific indeed.
We're kind of running out of time. It does sound as if Joanna needs at least an hour's legal surgery.
Yeah, but
in
that's
my view, because you could be getting into hot water. Contested will cases of any size and value,
yeah.
it's complicated.
Well, just to inform you, our legal surgeries cost £150 plus VAT.
No, they don't include VAT now.
They don't, so it's cheaper now. It's a cheap
Yeah.
£130. Whoop, whoop.
We're not going to be VAT registered to bring the price down.
Okay, well that's good. That's good news. That's really affordable comparing.
It is really, isn't it? Because that's quite a lot.
Yeah, I mean it's kind of like half price of a normal solicitor, even though you are a normal solicitor with like 30 years experience.
I know the big caveat is they won't have protections of insurance against. They can't bring a claim against us in the way they could a normal law firm, and they couldn't complain to the SRA about us. That's so there are caveats, but other than that, you're still getting the same level of expense. In fact, perhaps even more so, more practical hands-on experience with low and medium value claims.
Well, that's good news. I'm quite happy about that one. Anyway, so that's it for today. I'm sorry, folks, if we didn't get to your question. I'm sorry, but that's just one of the things with these free legal surgeries. They're all free. We're giving up our time and spending money for these to produce them. So if you do have a specific question or you're struggling with your case, either do get the book, download the free chapter at book.courtwingman.com, visit our website courtwingman.com for more information about us, and then get in touch on hello@courtwingman.com with your questions and book yourselves in for legal surgeries or preliminary case reviews if you do need it. And we only do recommend them when they're needed. We're not going to rip you or take your money from your wallet and give you bad advice. That's not what we do here. As hopefully evidenced via this free surgery. Any final notes, Alex, before we finish?
I think just going forward, I'm thinking the difficulty with these legal surgeries from where I'm seated is people have distilled their issue into quite a technical legal question, which is only going to embarrass me because truth just out, we don't know the law. We just know how to find the right law quickly. So Section 48, Ground 8, we just do not have that level of knowledge in the back of our heads. But we can get on top of that knowledge extremely quickly. But the better thing to do, rather than asking these questions in a technical legal way, is to open up a bit about your case, like Joanna did. I've got a wills case. I think the second will was forged. If you could tell us, it was a mother or whoever it was, and the caveat's been entered. We've then got. But we need to know what the dispute is before we start talking about the law. Because until I know what the issue is, we talk about issues a lot in the book, and the factual, and you can just boil it down into its bare basics. It's a good exercise. That's far easier to be able to give you advice. So try and think about, I'm in the middle of a dispute. What's the issue here that I need help with? Not so much, I think, the legal question that I need answered is, but what's the problem? What's the issue with the dispute that I've currently got?
I suppose we're kind of to blame for that because the session is called Ask Your Legal Question. So I think we may need to change the title a little bit.
Yeah, I'm sorry if people have come onto this surgery and been these guys don't know anything about the law. Well, this isn't an academic legal, general legal academic surgery, is it, Kinga? It's to help at a practical, pragmatic level with actually going into the trenches yourself in civil litigation in the county courts, not family, not employment. They're different areas, and Now, just one final thing is we are starting to get a lot of personal injury inquiries, a couple of personal injury cases recently. And because there's been, which we don't specialize in per se, but we're thinking of doing more personal injury work, and it may be that we'll be able to help more comprehensively people with personal injury cases in future legal surgeries and or future books and videos, because there's been a big change, and if your claim value in a road traffic accident is under for the injury itself, it's under 5,000, you can't involve a lawyer. It's quite a high threshold, so there'll be a lot of litigants, and that change has come up from 1,000 to 2,000, I think. So it's been quite a big change. It's meant that it's been a death knell of large parts of the personal injury legal sector. And basically it's bringing a lot of personal injury cases into the small claims ban, which means you're not allowed a lawyer, but those people will nevertheless probably want legal advice and assistance in the background. So I think it's an area of need going forward. So we probably will be going into personal injury work in the future.
Okay. Well, just on the point of the legal surgeries, we are running the next one in 2 weeks' time. So they're bi-weekly, always on a Friday, always at 12 p.m. UK time. And if you, because a lot of you have just now said that there's a character limit on the chat, so you can't really elaborate without chat. Anyhow, for next session, when we start, what we'll do is give you the link to our Zoom call. So you'll be able to then come into the Zoom room, not share your video if you don't want to, just share your voice and then talk about the issue. And we'll have like a lively discussion about that problem.
And there's no harm in people emailing in advance, is there? I mean,
no, there isn't.
Because if you email questions in advance, we could have a look at, we could pick out some ones that we think are going to be most useful.
Yeah, as long as the subject matter is clear at the very start, so we know what email to kind of go into before the session starts.
Yeah, in a way, anybody who's thinking of, it's kind of like a bit of a free lottery sort of thing. Anyone who's interested, thinking about coming to us for legal surgery, you can write up your email, nice story, and you might, if you're lucky, get your case discussed during the legal surgery. We could do 3 or 5 or 6, because I think that is partly the problem. And yeah,
well, I think going forward, this is a good improvement to make. So in 2 weeks' time, when we come here, and some of you might have follow-up questions, because I mean, cases don't just disappear in the space of a week, then we'll share our Zoom link and the email, and we can do it that way. So hopefully it'll be more efficient, and you won't have to sit around for 50 minutes and wait until your question is answered.
Yeah, we'll try and be, good point, Kinga. Let's try and be more productive and efficient. Yeah, good. But do think about sending a query through in advance to what? To hello@portwingman.com?
Probably best, yes, with the subject line, YouTube live, and that'll be enough, as long as there's YouTube on there.
What do they put in the subject box, so we know to
YouTube live.
YouTube live in the subject box.
Yeah,
YouTube live question. Okay.
That'll be nice and clear for us, won't it? And then we can pick
exactly, and then we can cherry pick, and yeah, I think it'll make these sessions far more efficient.
Definitely. Anyhow, this is all we have time for today. Unfortunately, we already went over 20 minutes. Thank you for being here. Thank you for your patience. Thank you for giving us interesting questions. Do click
challenging ones.
Do click.
I feel pretty ignorant right now about the law.
Indeed. Please do leave a comment, a like, and subscribe to the channel, because it does help us get into the algorithm and show up in front of people's faces that may also need legal advice. So you really would be helping us. Anyhow, thank you all. And
buy the book.
Yeah, buy the book.
I think we should have it on the shelf behind you, or something cunning like that.
Oh, where my
Yeah, put it in a cunning strategic position.
Okay, well, next time I'll know to do that.
Yeah.
All the details can be found on courtwingman.com. So the telephone number, all the links, the book, our services, everything is there. So do go there. Thank you so much for being here. Enjoy your weekends and see you soon.
Thanks, folks. Thanks, Ginga.
Thank you.
Bye for now.